SJC-10329, Commonwealth versus Pierre.
Have to fix the clock sheet.
Thank you.
Good morning, Mr. Blesson.
Good morning. May it please the Court. I'm Kenneth Bressler, representing the Commonwealth. The touchstone of the Fourth Amendment, of course, is reasonableness. This Court reaffirmed that touchstone just 2 days ago in Commonwealth versus Natu.
We have Article 14 in this case, though.
Yes, we do. And Article 14, of course, invokes the same key word of reasonableness. And I contend that the touchstone of search and seizure law, Fourth Amendment and 14th Article, is reasonableness. And
So you say it was reasonable for the police to throw the bag into the car and then tow the car and then do the search?
yes, it was, Your Honor.
Why? Because it was raining? Is that it?
It was pouring rain.
Well, what if it wasn't pouring rain? You used the word pour. How about it just plain rain, a drizzle?
Like the last couple of days.
Yeah. Would that be different?
I think it would be different, Your Honor, and it was drizzling earlier in the day, and at the point when the police came to take control of the plastic bag, it began to pour.
So the pouring, in quotes, that's something that both parties agreed to? It was pouring?
I think that the fact that it was pouring at that point is not in dispute.
Did the Commonwealth argue the safety of the police and the dangerousness of the situation before the motion judge?
It did, Your Honor.
Did, okay. Then I have another question about the inventory policy. I realize it may not be important in this case, but is there a requirement that a written inventory policy be introduced? And do we need to discuss that issue because there wasn't even any testimony about an inventory policy? As I understand it, I haven't read the transcript yet.
There was no testimony about a written policy, and the search cannot be upheld as an inventory for that reason. The law, as the Commonwealth argues it, however, is that at the suppression hearing there must be evidence of a written policy. The best evidence, of course, is the written policy itself, but the Commonwealth can still introduce evidence through testimony of the existence of the written policy. That didn't happen in this case either.
So why? I mean, if you have a written policy, let's have a written policy. You don't want to have a police officer saying, I think the written policy is, or this is my understanding.
If a police officer testified to, I think there's a written policy, or this is my understanding, or was vague about the details, which is akin to what happened here.
Why would we, in this particularly difficult context, if there's a written policy, introduce it in evidence?
Well, the court has said that that's the best practice, and of course that makes sense. But conceivably, there are times when the testimony about the written policy could be so detailed that it would suffice under law.
But you can see that's not the basis here.
No, but why is it
That's
so
not the basis
why
here.
is it so difficult for the Commonwealth to get a copy of the written policy and put it in evidence?
Isn't that really what should have been applied here? That this could be done under an inventory search because it was getting taken to the police station?
Well, it would not have been difficult for the Commonwealth to introduce a written policy or
In
testimony.
any case. In any case.
And that certainly was anticipated by the police that at any subsequent suppression hearing there would be.
So why wasn't it introduced here? Just, how many cases we get? I mean, I just can't repeat it enough. They just don't seem to be prepared at all. Well,
On the record, there were two parts to the suppression hearing. There was an evidentiary part and an argument part. They were conducted by two separate assistants, and all we know from the record is the assistant who conducted the argument part said he did not know why it had not been introduced.
Mr. Blesser, let me go to what I understood was the gist of Justice Botsford's question, which is, this is an inventory that took place.
Correct.
Right.
Under one theory.
Right?
Under one theory.
Yeah. Well, I mean, that's really what happened here. right? There was no safety involved by the time this was back at the police station and so on and so forth. That is to say, I think it's perfectly reasonable when a police officer knows that an automobile is going to be towed, and I take it that a police officer knew that this automobile, or was it an Audi or something or other, was going to be towed, correct?
Correct.
And that it is absolutely standard policy that you can inventory everything in the automobile, correct?
Correct.
So this is an inventory search. So the Commonwealth messes up, right? I'm not blaming you, and I don't even know who the assistants were. And they don't, there's a motion to suppress, and it's just an open and shut case. Here's the written policy, assuming there is a written policy. And the policy gave us, and we complied with the written policy, end of case, motion to suppress, denied. Because the Commonwealth makes the mistake, we now spend enormous judicial resources trying to come up with some other theory that nobody thought was at issue. Why would we be doing this?
Because the issue that was on the mind of the detective when the plastic bag was searched was not dispositive. There are other legal theories always available, even if not articulated necessarily at various stages of the proceedings. And the search of the bag was also justifiable as a search incident to arrest.
It didn't take place incident. I think Chief Justice Lopez is absolutely correct. It didn't take place incident to an arrest.
The
I
Commonwealth
mean, the
looks-
search occurs when the man is arrested, gone, not even in sight, correct? The defendant?
That's correct under Justice Raposo's the cases he cites, and the Commonwealth will point to the Edwards case and the larger holding that the search can still be incident to arrest, even if there's a substantial lapse between the arrest and the subsequent administrative processing.
Well, the Edwards case, though, it really deals with stuff that remains in the possession of the individual at the detention center, his clothes. They could search his clothes afterwards, but it says, once an accused has been lawfully arrested and is in custody, the effects in his possession at the place of detention that were subject to search at the time and place of the arrest may be lawfully searched. He's still got them. They're still on him, in other words, as opposed to a piece of luggage that's been separated from him and is in the tow lot somewhere. Isn't that the big distinction in Edwards?
That is a distinction that can be drawn with Edwards, and that's certainly the facts under which Edwards arose. I asked the court to take a look at the larger holding of Edwards, and that there can be a separation
You can do that,
between...
but that's Fourth Amendment case over 4 dissents, pretty articulate dissents. So whether or not we want to go that route, I mean, we pretty well said, as Chief Justice Raposa laid it out, incident to an arrest is when you're arresting. Why would we, and again, it's not in this case as if there wasn't some remedy for the Commonwealth. I mean, why would we want to create what could be all kinds of difficulties? I mean, the presumption always is that you need a search warrant. So we carve out areas, where you don't. But I don't think that our jurisprudence is when you carve it out, you make it as broad as possible. The presumption is the other way around.
Of course, Your Honor, and the Commonwealth points out that there's no conduct here to deter if the gun, in this case, were suppressed. The only thing that would be deterred is the reasonable behavior of police.
No, what are other things at issue is the amount, time, delay, judicial resources, because the Commonwealth doesn't do what it should do. I mean, in other words, for whatever reason, there were perfectly appropriate ways to search this bag.
Yes, Your Honor, and they were not. They were the easy justifications did not happen here.
But maybe they did. I mean, for legal purposes, we obviously can't say it was an inventory search, but it probably was an inventory search. In fact,
At the time it
and
was.
the Commonwealth just
At the time it was, and
the Commonwealth just didn't put in the proper evidence. Period. End of story.
well, if I could add an epilogue, which is that a search incident to arrest is also available. That's the Commonwealth's argument, even if it were not necessarily in the mind of the detective at the time.
Don't you, I mean, it seems to me to do this, you have to turn the presumption, that is, warrantless searches are not valid, on its head. we're seeking to find some theory that will uphold this search.
Well, there were multiple theories that upheld the search and existed at the time, including search incident to arrest, not necessarily articulated by the detective and not articulated by anyone until the motion to suppress. But we're asking the court to look at the larger touchstone of reasonableness under the Natu case and other cases that point to that as the touchstone of the Fourth Amendment. What the police did at the time was engage in pragmatic necessity, and the motion judge did that as well by upholding the search.
I take it that Mr. Pierre, despite Chief Justice Raposa's ruling, has served his sentence. Is that correct? I mean, in other words, by the time that decision came out, he had already done the time that was imposed by the district court. Am I correct?
I do not know about the underlying charge, and the record doesn't contain information about.
I thought it did give a sentence, but I don't remember what it was, but I thought it was in there.
The record doesn't disclose other possible proceedings.
I see. Okay, fair enough.
If there are no further questions,
Thank you.
thank
Mr.
you.
West.
Commonwealth rests.
Ms. Kavanaugh?
Lisa Kavanaugh, Committee for Public Counsel Services, on behalf of Mr. Pierre. Just, sorry, to briefly answer your question, I think the record is clear. He did complete his criminal sentence in this case.
Should there be a requirement that if a case is pending, this court sometimes issues an order when the justices have reached a conclusion, but it may take a time to frame an appropriate decision? I mean, when we have, should counsel be saying to the appellate court, look, you know, we think there's a meritorious claim here, and this is a short sentence?
Well, certainly, I feel that would be helpful, and I think that it's a shame that he completed his sentence here. I can't explain why it is that the decision in the appeals court took a year. It was argued in September of '06 and not decided until September of '07, and that I don't have any explanation for that. But certainly, it was in the record of my appeal of the court's judgment that the length of the sentence.
What was the length of the sentence?
It was a two-year House of Correction sentence that was imposed concurrently with another similar sentence of similar length.
And when the case got to the appeals court and was argued, how much of the sentence had been served?
He was released in April of this year.
Excuse me, you just said that the sentence imposed was 2 years concurrent with another sentence.
Another 2-year
So
sentence.
if this had been reversed, he would have served the 2 years anyway on the other sentence?
Yes, although as it turns out, the issue at stake in this case also affects his other conviction. But yes, in fact, a reversal in this case would not necessarily have resulted in his immediate release here under the circumstances of this case. It sounds as though I don't need to repeat everything that's in my brief, but I do think that
Which was an excellent brief, by the way.
Thank you, Your Honor. But I do think the salient issue here is that this was essentially an inventory search, assuming that the Commonwealth had been able to establish the existence of a legitimate inventory policy. And I don't think it would be such a far or enormous leap of logic to assume that most written inventory policies would have encompassed the sort of search that occurred here. And it simply does not make sense for this court to go in a completely new direction with regard to the search incident to arrest law under the circumstances of this case.
You had all of 2 days to read Natu, but how would you distinguish this case from Natu?
Well, actually, I happen to be the amicus author in that case, so I'm quite
All right, so
familiar
you
with
can.
it. But I think that there's, I think as a starting point, Natu certainly, says, as other cases have, that the touchstone of the Fourth Amendment is reasonableness. But here, the question is, was the search reasonable as a search incident to arrest? And it's not reasonable as a search incident to arrest unless it complies with the requirements for that exception, unless it serves the underlying purposes of that exception, which are either to protect officer safety or to ensure that evidence is not destroyed. It's not simply a free-floating standard that is meant to be applied without reference to the existing doctrines. And as I believe several judges have pointed out, The presumption here is that this search was a warrantless search and was unreasonable, unless the Commonwealth establishes that the search fell within one of the well-delineated exceptions to the warrant requirement.
This search, unlike, do you say it Natu? I always said Natu, but in any event, do you, that one was first, I think, was done at the scene, right?
Yes,
I
he
think.
put his, the officer searched the bag that had been left on the public road because, and I think in Justice Island's opinion, he says this, the officer knew that this person had had a prior arrest, wasn't that the case, Justice?
That's right.
For a gun offense.
For a gun, so that it was...
This one was done at the station. is
This
it?
one was done at the station, and I think another important distinction is that in Natu, the principal issue was whether the defendant retained an expectation of privacy in the bag, having left it at the side of the road. And although I obviously took the position that he did retain that expectation of privacy, that was the framework that the court was working within in determining the constitutional significance of that search.
Sure. But I think the reference to the fact that the police officer, Mr. Bressler, very kindly gave us a copy yesterday, was that he knew, I mean, this wasn't a police officer just going to pick up a bag and slinging it in the back of the cruiser. He had, there was some suggestion in the record that he had reason to believe that something might be in the bag that might be dangerous.
Certainly there was some evidence there of that. I think that clearly this case is distinguishable, among other reasons, on the basis that the search here doesn't occur at the scene. The officer who puts the bag into the car must not have had a safety concern attached to that bag if he decided to put it in the cruiser without first searching it in Natu.
Was that in the cruiser or the car that was towed?
It was in the car that was towed.
Okay.
So he places this bag into the car that was towed. And I think the important thing there is the moment where he chooses to do that is a moment where all of the immediate safety concerns that were attached with the arrest, the fact that there had been multiple people involved in the arrest, those issues had been fully resolved by the officer at the point where he chose not to search the bag, but instead to place it in the car.
Ms. Kavanaugh, I certainly don't mean to, beat up on the Commonwealth at all, but I haven't looked at the record. Do you know why? Was there any discussion of inventory searches and at the hearing?
At the hearing, in the record, the officer testifies that he put the bag into the car, intending to tow it to the station pursuant to the Lynn inventory policy. So there is a reference to the existence of a policy. The officer clearly believed that that was what would happen. And his description of what occurs when he gets back to the station is consistent with that expectation, which is that he returns to the station, the police begin going through the contents of the car, and in the course of going through the bag, they discover this bag.
That's what Judge Raposa said in the opinion. He quoted the officer. He stated that he did so because during the course of the arrest, it started to pour rain, and we were going to inventory the contents of the vehicle.
And that's exactly...
So that's what the officer was thinking.
That's right. And I'm certainly not taking the position that because the officer said that necessarily ends the inquiry. But I think that the broader concern here is why should this court or any court stretch this doctrine far beyond what other courts have done, far beyond what the Supreme Court has been willing to do, simply because the Commonwealth didn't bring in evidence of an inventory policy. And I think, the Commonwealth refers to the broader holding in Edwards. Well, Edwards was decided in 1974 by the Supreme Court, and 3 years later in Chadwick, the Supreme Court again addressed a similar issue and limited Edwards specifically to searches of the person and the effects that are brought with him. So this is not something that occurred in a vacuum. The Supreme Court itself has spoken on this issue, and this court has over and over again emphasized that searches incident to arrest must remain attached to the underlying justifications for those searches, which are officer safety and protection of evidence. And I simply don't think that this case warrants some significant departure from that requirement, which would clearly be necessary under the Commonwealth's position. And I also just want to point out that the Commonwealth suggests that this is going to create some bright line rule. I think there's nothing bright or clear about saying that a delay is okay as long as it's reasonable, because that's still going to require an ad hoc judgment by the court, by the officer in the field, about what's reasonable. Is pouring rain, is drizzling rain, is it the presence of more than one person at the arrest scene? those are all sorts of questions that are not resolved by the Commonwealth's rule here.
Thank you, Ms. Kavanaugh.
Thank you. If there are no further questions, I'll rest on my brief.